One of the questions I often get from my clients when I'm about to go through this method is, hey, well, what should I say, right? Or what questions are you going to ask me? What am I supposed to say? It's almost like they come to my office. I understand why, but they come expecting a script.
You know that is always in every client that you have. They really want you to tell them what to say. Please do that work for me. I'll just memorize what you say. But it is amazing to me sometimes where I'm like, please do not memorize what I am saying, because I need you to use your words for it to be real, because we're talking to juries here. We're not talking to other lawyers.
This is RVA Trial Lawyers, Virginia's trial lawyer podcast, hosted by Sharif Gray and Niall Abuzaki.
All right, we're back, RVA Trial Lawyers, and today we've got Elizabeth Lerrick. Elizabeth, thank you so much for joining us. As you know, I'm a huge fan, and I believe I finally got your autograph. What was it, a month or two ago, after you helped us out with that case against Ford. But anyways, in all seriousness, I've used your witness prep method many times. I've seen colleagues use it, and it's something that has made a huge difference for my clients in their cases and ultimately me as a lawyer. So really excited to have you on the podcast so we can learn more about witness prep, specifically for prepping your client and maybe some other critical lay witnesses for their depositions. But before we get into that, why don't you go ahead and introduce yourself?
Well, first, thank you so much for having me on your podcast. I love watching it, and I love seeing always the clips on LinkedIn. So I'm excited to be here. And also talking about depo prep, talking about trial prep is one of my favorite things. It is truly a passion of mine that really set me on the trajectory of where I am now. But I am a plaintiff's trial lawyer through and through. It's what I did for so many years. I ran my own office. And have turned into doing just trial consulting now. But background-wise, I am in Texas and have worked in Oklahoma and Texas, but now work kind of nationwide. And you obviously learned a little bit about the witness prep through the same place where I did too, which was the Keenan Trial Institute. When I got into it, it was reptile, edge. So anyhow, we can get into those fun details, but I'm excited to be here.
Well, before we get into those details, can we learn a little bit more about you? And why you became a lawyer, what drew you to this type of work?
Sure, absolutely. So I, at a very young age, had many interactions with the legal system through family law, and I had a sibling who had some criminal law, and really had an impact on me very early on that lawyers make big decisions for people in their lives, and wanted to be a part of that system. And understanding that lawyers played a very crucial role in navigating that system. And I just knew I wanted to be in the courtroom because that's where I felt decisions were being made, and just set myself up. I'm going to go to law school. I was one of those people who I feel is very fortunate to know, that's what I'm going to do. And that's what I set my sights on. And off I went, and North Texas undergraduate, and then went to OU for law school, and found my way into doing I did criminal law, when I was in undergrad, as far as working in an office, and then went into law school and just tried every internship I could get. I worked at the public defender's office. I worked at a personal injury office. I worked at defense personal injury. I worked at insurance subrogation. Anywhere I could get a place to just see how it works and see if I liked it. And ultimately, plaintiff's personal injury work is really what drew me in. And that's what I've always done, and was grateful to work a couple years in Oklahoma, and then made my way back to Texas, and then eventually opened my own office.
And you remind me, but you had an opportunity to do a fellowship with Don Keenan. Is that right?
I did. I opened my office, and then within a couple months, I had an opportunity to go work for his office. And so I did that for a year.
That's incredible. So, when I took, I think 5 or 6 of his courses, and just the framework, right? And the way to actually look at your cases, for me, it transformed everything, right? In a number of different ways, but I'm super grateful for having gone through that training. I can't imagine what it would have been like to spend a year in that system working with Mr. Keenan. So I'm sure you learned a ton.
Oh yeah, I mean it's like drinking from a fire hose. I mean, back when I first started doing the same thing, there weren't courses. You just went to seminars and just basically bombarded with all this information, and it was such a wonderful community as well. And then like being able to be along, like I was very grateful to be put on the stage and start speaking very very quickly. And witness prep was the thing that like I was immediately drawn to, and so I've always gotten up there. They've always been very supportive. And then when we did they turned things into the courses, then, naturally taught lawyers for many years, and then working alongside and seeing trials. It was really like full on application, right? Like you learn all these things, but then having that place where you can see it in action is amazing.
What was it about witness prep that drew you to it?
Well, I think from my standpoint, where I was at the time that was pretty much the work I was able to do, right? Oh, here you go. You want to get into litigation, you're going to go present the client, right? And follow the traditional methods, and was very frustrated by those. And when I found kind of this method, I really was drawn to it because it's a little opposite, right? It's very much listening and helping them organize things. But when you see it actually work and see people be able to tell the story in their own words, and just the magical difference it makes for people mentally, like to be able to do that, it really took off for me. And ultimately, I had probably blocked some memories, but I actually had to testify when I was about 17 years old, and I did a terrible job. So I think this really kind of tapped into, that thing that I wanted when I was sitting on the stand. And that's why I was drawn to it, and was just like, how can I then make this better? Like, how can I really help people to play the best part they can in this case, do the best part in their role, but also give them something mentally to close that book in so they can move on with life.
Now that I think about it, there really isn't too much instruction on witness prep, right? Like in fact, I don't think and maybe it's just because I haven't hit the right book, but there just aren't that many publications out there that talk about how to go about witness prep, and until your method, right? Or the method that you helped create. And so let's dive in. Can we go into, I guess, first off, like, how did you even come up with this method?
Well, let me take a step back, because obviously this is Mr. Keenan, in his litigation work, created this template and taught it to everybody. If you went to the depot seminars, it was there, in a lot of blogs that were put out. And I think really where a lot of the, not necessarily changes, but just, ways to look and improve it came through teaching it, teaching it to other lawyers and how to really incorporate visual aids. And that's one of the things I feel is like one of the strongest things we can do better in teaching people is incorporating visual tools and being very engaging and doing those things together versus old school method, hey, watch this video and then show up. Or, I don't know if you guys had the horrible like 1980s video where it was just like, you're going to be deposed. This is what it looks like. And it was horrible. So, but that's kind of where teaching others really kind of transformed that template into something more and making it easier for lawyers to apply.
Makes sense. So for this particular method, what is the goal when you approach a witness to try and prepare them for their deposition?
I think the goal is what any method would want, which is you want clear testimony, you want people to be credible, and you want them to be as comfortable as possible. I think a lot of very common mistakes that people make is they get surprised, right? Something's very unexpected. And they're very good at telling you what happened, but it's just very confusing. And I think that's where, having done so many focus groups, you get a good fine-tuned ear for what is clear testimony and was not. And so I think the goal of the template, the method, is for people to be as comfortable as they can, right? Try to move surprise, but then have confident, clear testimony that is very credible.
So before we get into some of the things to do, right, like incorporating visual aids, what are some of the big things that you've seen that lawyers should not do when it comes to preparing their client or other lay witnesses for their depositions?
Sure. I think for us, it's so natural as lawyers to really want to show a client, like, this is what it will be like. And they kind of turn on that cross-examination mode. And lay witnesses, clients walk in, they don't have any context for that. And so it's very fear enticing. And it's very difficult once you have somebody who's in full on fear mode for them to like be able to calm back down and then start learning things. So without a lot of context, a lot of lawyers jump right in. And, this is how terrible it's going to be. Or if you say this wrong thing, like, it's very kind of fear inspired, which it all comes from a place of wanting to help people get prepared. I totally understand it. But you also have to think through that traditional prep, which is like, don't say anything other than yes or no, which is like our fear that they're going to say something wrong. So it coming at it from a very don't do this perspective. I'm going to grill you with this cross-examination. I'm going to show you how terrible and terrifying it's going to be right off the bat is really difficult to overcome when you're trying to teach a client about how it works and trying to encourage them and kind of pull out the information they have and help organize it with how the questions will be given. So that is, I'd say, one of the biggest mistakes that I see. And even when I work alongside lawyers, even today, when I see that happen, I really I try to back it back down. Like, okay, well, let's just take a second. Like, let's do a few things before we jump into cross-exam, before we jump into role play. And clients walk in and they want role play. Like, tell me what questions it'll be. You've really got to resist that as a lawyer and take them down the path, give them context before you move into that role play practice.
I know one of the questions I often get from my clients when I'm about to go through this method is, hey, well, what should I say? Right? Like, or what questions are you going to ask me? What am I supposed to say? It's almost like they come to my office and I guess I understand why, but they come expecting a script. And what I've learned, at least going through this method, is that that's the last thing I want. It's not effective, right? It doesn't work. Nobody in the heat of the moment actually remembers what to say. And two, it comes off as inauthentic and it's something scripted, right? Which is just not what you want. Is that something that you run into as well when dealing with lawyers, is that they have their answers that they want and they're trying to instruct the witness to basically give those answers?
Yes. And also it's unethical. Let's start there as well. Sure. Like, people worry about coaching people, and this is like over coaching people because that is always in every client that you have. They really want you to tell them what to say. Like, please do that work for me. And when lawyers step into that role and they do it, it's like, it really relieves that, like, oh, good. Well, I'll just memorize what you say. But it is amazing to me sometimes where I'm like, please do not memorize what I am saying, because I need you to use your words for it to be real, because we're talking to juries here. We're not talking to other lawyers. That's who our audience is. So absolutely, I have people tell me what to say. They just want to know what the questions are. They'll figure it out on their own. Or the other question I always get is, well, what happens next? Right? Like, they already want to be thinking ahead of like, okay, please tell me this is the last time I ever have to do this. They want to know what that big picture is, even though you may have told them 1,000 times, until they actually step into a place where they have to be an active role player. They really don't necessarily always get the big picture.
Got it. No, that makes sense. Now, Elizabeth, a few minutes ago, you mentioned using visual aids with witness prep. Can you tell us a little bit more about that?
Absolutely. I think, depositions are kind of sometimes just a giant memory test. And most people don't have great memories. We have short-term, we've got long-term, and we've got plenty of other things to think about besides our lawsuit. And so using a timeline, just putting one together with your client is a great way to do a memory refresh, especially if you're going to go through in a personal injury case, like medical, a medical timeline. And it is not complicated. It's just draw a line on a dry erase board and start putting some dates up there. That's probably the easiest one that I always suggest people start with when people give a lot of hesitation to writing on a board, or, well, I'll just have my assistant put that together and we'll just put it in front of them. Like, there is a really big purpose about actively getting their memory engaged and doing it out loud and then writing it instead of pre-creating it and just handing it to them, right? There's not a memory jog. That's just memorization of like things on a piece of paper. So
And that kind of reminds me
Timelines
of
are
the law school outline. Like it's two completely different things. One, to go just find the good outline and try and rely on that. And then two, create your own, right? Like you get nowhere just borrowing someone's outline. You get everywhere, right? You get what you need at least when you have to go through the process of creating the thing on your own. Because then by the time of the exam, right? Actually, this might be a good parallel to the witness prep. By the time of the exam, you don't really need that outline anymore because you did the hard work to create it.
That's right. Yeah, there's a lot of active engagement just creating that. So a timeline is a great one. There's another one that we do. It's a T-chart, and basically it is where you as the lawyer are going to fill in the left side with what the defense strategy point is and all the questions. Like, for example, gap in treatment, right? Clients have a really hard time even grasping what are the weaknesses and how are those questions going to be asked. So with this visual aid, it's you do your side, the left side, and then you hand it over to the client to fill in their facts and the truth on the other side. And what that does is really allows them to visually connect up. Oh, I do have the answer for that hard question. Or, oh, I would have known where they were going, but now I can see like this question falls under, gap in treatment. Oh, because you didn't go to the doctor, like you're not hurt, right? So it really helps them kind of see everything without, if I verbally told you all of those things, like we really can only hold in our short-term memory, like 3 to 5 things at a time. But if we write it down, they can really visually see it. And then as they have to go through and engage in their minds, like, oh, well, what was happening at that time? Like what are the facts that I have that would answer that question? You're connecting things in their brain, create new pathways. You are helping them organize, and you're using all of their words. And it's just a simple T-chart. There's nothing super magical about the diagram itself other than you both engaging in this process of organizing testimony directly with questions that they're going to get.
This is my favorite. That's my favorite, or frankly, it might be one of the most important parts of the witness prep. Or for me, it's like the foundation, right? It's list out all of the defense arguments or the lies, or you don't deserve compensation. You aren't hurt as bad as you claim you are, all that. And then you don't give the witness the answer, right? You work with the witness to basically rebut that lie using the truth and their voice, right? So in some sense, it's like the lawyer is just the facilitator, right? Like you're not, I mean, you'll ask more questions to get them to jog their memory and stuff, but really my take from this method is that you are empowering the witness to fight the good fight. So really they don't need you come time for the deposition. Is that a fair goal for it?
Yeah, I think that's an excellent way of saying it, because it's the easiest way for us as lawyers to keep engaged. We just ask more questions. Is that true? How do you know that is not true? Tell me how you know that's not true. Don't just tell me how you feel about it, right? Because we know they're going to be angry, right? Because how could they say those things to me? It's like, well, they're going to infer them, but I want you to know what those things mean here and now. And then in your brain when you get in there, oh, I have an answer to that. I know how to fight back. I know what the truth is and I can stand with it.
And you know what? I found it also helps me like learn more about the client, right? Because you can't, if you're going to spend, what is it? A full day, it's 3 days, right? Day 1 with the client, then day 2 is that mock cross, day 3 is another mock cross, just a little bit shorter. But that day 1.
And there's in there somewhere. Yeah.
Sure. I mean, you learn so much, right? I mean, or you just can't help but learn a lot about your client, which I've found as a lawyer, like it helps me with the trial prep. Or what, I mean, I know we can't go into the actual details of what the method looks like. Where can people learn more about how to actually go through the method?
Sure. I mean, you can. So Keenan Trial Institute teaches the witness prep virtually. You can take the virtual class. But I think even for folks just sitting here listening with us, it's easy to know. It's basically breaks it down into 3 steps. And step number 1 is making sure that your client has the right expectations about what's going to happen and what their job is. And, that's really where we want to have a good mindset. We want to have good context. And that's where you're saying like, that is, a place where we learn so much because we just ask so many questions, right? And it's very much a listening step. And then step number 2 is where we really get into what I call our meat and taters. Like, we're really getting into the questions and helping them organize and listening to them and asking more questions and helping them organize things in their brain. And then that last step is that role play, right? We practice, like, are they getting it, right? Is it connecting up? And so those are the really kind of the big steps that people take. And the framework is a little different than some of the things you may find that's on the internet, because basically it's a list of do's and don'ts without real engagement. And that's why this prep is so wonderful, because you ask so many questions, you really personalize it. And when you personalize anything, people are there, they are engaged, and they want to keep going forward versus you just giving them a generic list of do's and don'ts.
Sure. Or just tell them, go watch the video, right? Or read the handout. Right?
That's right.
So,
yeah.
At what point, Elizabeth, through this kind of journey of like learning the method, improving upon the method, were you like, yikes, this works? Like, this is the right thing?
Oh, immediately. I mean, because if you go out there and you try traditional methods and you sit down, you go through the discovery with people, you try to answer the questions, you try to do role play with somebody, and then you see them go in there and just really struggle, and it's hard for you to watch that. But then even if you fumble through it, you're still going to see a huge improvement with how people feel about how they did, how their testimony actually looks on paper. It's much clearer. And then oh my gosh, like, you see it, they feel better about it. You just keep trying over and over again. But I mean, for me, it was almost instant because I was making so many of the terrible mistakes. It didn't take much to improve it, but I saw improvement almost immediately.
Is there any case that kind of stands out to you where you're like, that's the example I'm going to use when I'm trying to sell this method?
Well, I don't feel like we need to sell it.
That's right. No. It's quality speaks for itself. So
yeah, I mean, I've had so many amazing clients that have blown me away, how we're so strong, and they really came in and just wanted so much guidance, to the point it's like, tell me what to say. A couple of the beginning cases, whenever I was starting to help other lawyers with witness prep, was a young girl. She was 16 at the time. She had terminal cancer that they failed to detect. And she was fighting the cancer, but wanted to give a deposition. I mean, she just was this fighter and just had this fire. And we go in there and she's doing awesome and she's doing excellent. And we have to cross-examine her. And, she just fights through the tears, and she's such a fighter. And so just to see that, and then her go in there and just like crush it in her deposition and go all the way to trial. And she does end up passing away, but just knowing that she felt so good about being able to stand up to the people, to stand up and say what happened to her, was really just so powerful. And I've seen so many other examples of that where, somebody comes in dead set on, I'm going to blame this person, when that's not really, the defendant that we have, and being able to really work with somebody and have them come to their own realization. That's the beauty of the method. And just having people do that in front of you is it's magical.
It's empowering, right? I mean, for the client. And really, like, that's a big part of a client's goal, right? I mean, sure, compensation is every client's goal to some extent, but the recognition that they were hurt at no fault of their own, and the recognition of the suffering that they had to endure, right? And to be able to go in there and face the person who hurt you, or at least the defense team that hurt you, and confidently tell your story. I mean, that's huge. That's huge.
There is power in just being heard.
Right.
And I think that is something that a lot of lawyers shy away from, because they think people are going to talk too much. They're going to overshare. They're going to over-explain. It's like, well, that method, it takes that into account, but it also takes into account the huge amount of just amazing psychological, like, relief people get just from being heard, right? So there are a lot of clients, I'm sure you can think of one, where they're like, I want my day in court. And it's like, let's let's go to the deposition. Let's knock that out of the park first. That's step one. And if we have to go to the next one, but just know, like, you've laid it all on the line. You've done your job. You've done the best job. Like, is such a wonderful thing for a client to hear.
If I remember correctly, like one of my recent cases, I remember when I did the witness prep method, I remember the client, I mean, he was super nervous about the deposition, right? I mean, because if you think about it, a client, they testify at their deposition, they testify at trial, they help you with some written discovery stuff. But other than that, I mean, that's kind of all they have to do. The lawyer more or less does everything else. So in many respects, a deposition is a Super Bowl for that client. And so getting them kind of through that was huge. And I found with many times with clients, like once they get through that deposition and you've invested in them and they knock it out of the park, God, I mean, they feel great, much lighter than beforehand. The weight off the chest is what I meant to say.
Yeah, absolutely. Chip off their shoulder. I mean, many times they're very upset. And I think that's one of the other things that this method does is really position the client to feel like they are actually playing a role. I mean, they are. I mean, decisions are being made, but if we don't frame it up that way for them, they'll just go in there and go through the motions. It doesn't really matter to them. But knowing them and empowering them that they have a role and this is the place, right? This is what we want you, this is where you go to say all these things. Because at trial, it's very different. It is not the same at all. And so that's why I really want to empower people in deposition to really feel like they've had their chance and had their say.
No, absolutely. So for those who want to learn more, it's the Keenan Trial Institute, right? And I think they're doing mainly virtual courses now. I've been to the Atlanta office for a course once or twice, but for the most part, they're virtual. I took the course, learned a lot. Obviously, love it, considering we just spent the last 25 minutes talking about how much I loved it and how everyone should go and take this course. But in all seriousness, I mean, it's given me, it's added to my toolkit in ways that I think have really helped clients. So for anyone who is interested in learning more and taking that witness prep to the next level, highly recommend taking that course. I also think it's helped me as a lawyer with my direct examinations in some respects, because I am able kind of to get to the heart of things a little bit better. One, I know about it because I spent the time with the client. And then two, I think you just get better asking those questions over and over again. So anyways, it's really good stuff. Well, so in addition to witness prep, I mean, you also do a ton of focus groups. Is that right?
Yes, I do.
And why is that?
Why?
Yeah. Why do a focus?
Well, I mean, as you know, I was very fortunate to get out of law school, start right out, at a trial law office. And that was my first seminar. And so I was, this is the way, gone through all the training as far as thinking through your case in that reptile kind of edge way. And so focus groups are it. And so really learned how to do focus groups. And then when I opened my own office, I was like, I got to do focus groups. So I just love them, and, doing them for my office. And then really other people said, oh, hey, you like to do that? Will you do that for me? So that's why it's a large part of what I do now to help people just in their cases, just thinking about case framing, but getting ready for trial, like we did for the Ford case. They're very flexible, of course, started doing them in person. We do a lot of virtual now to help people where they are. Why
are they so important?
I think as lawyers, we're ingrained. We've been trained a certain way, and it's very hard then to try and think about it from a layperson's perspective, from a jury's perspective. And we get really entrenched, especially, we love our cases, we love our clients, we want, justice. And having that outside perspective really helps us see things from another light, see blind spots. We may think it's the strongest argument, and they'll tell you they don't think anything about it at all, right? So it's really helpful to frame things up in a way that you're not locked into your point of view. And I think it helps with being curious. I think it helps with being creative, thinking about how to ask deposition questions, thinking about your opening, thinking about language and what words to use for jury selection. There's so many things that it goes into. And when you do focus groups yourself, I mean, this is one of the things that I was talking with another jury analyst, and she works with an office in office. And I said, why aren't you making them get up there and do it? She said, what do you mean? I said, you gain so much communication skills from getting up on your feet and stumbling through a neutral narrative or stumbling through jury selection questions. Like it really helps with your communication skills and listening when you do focus groups.
I've always found the hurdle of like the recruiting and then making sure you don't screw the thing up with the narrative, right? Like, I mean, I know you're a big proponent of getting lawyers to do their own focus groups. What are ways to kind of, I guess, bridge that gap to get the lawyer from not looking at it as, oh, we have to spend all this money to do a focus group, or we don't do a focus group at all? Kind of what's the happy medium that makes them more accessible that you found?
Well, I think virtual makes them super accessible, but I always tell people like, listen, you know, you're going to struggle with doing something neutral. You know what? Just relax, do an opening statement. Like just go with it, right? Then have somebody else ask the questions, right? But don't fight your instinct. And because there's going to be somebody else who can do the questioning, and they can be simple questions, right? But I know a lot of people struggle because they feel like I'm too biased, or like you said, it's going to be difficult to find these people. And here's the thing: there are tons of people out there who can help with just recruiting. Just Google them, right? You find somebody, but most of the time people try to put a little bit of a barrier. Well, it's going to be too complicated, or this is going to detract from the other things that we're doing in our office. And any office that I have helped put these together, or, you know, watch them, that they do them regularly, they're like, we can't practice without them. Like it just makes so much more sense just to get over that barrier of starting them. And, you know, I know Jessica Brillo was on here. She's got a paper about it. I've got blogs on my website about how to do them. I mean, if you feel like you can't be neutral, just try something else. Just do jury selection questions. I mean, there's so many things that we can practice in our cases. Don't force yourself into a box or into saying no because you don't think you can be neutral.
No, absolutely. Now, in terms of the recruiting piece, I mean, is there a shortcut to that? And I mean, because of course, when people think find jurors, are like, all right, go to church, put out a flyer, or get on Craigslist, right? Or what can lawyers do short of course, hiring a professional like yourself, or to do a good job with recruiting? Because I mean, the big thing is, right, like with all focus groups, is that if the stage or the settings aren't correct, then you can't rely on the results. So, right, the junk in, junk out analogy, right? I mean, you can get the most amazing results in the world, but if the way you went about doing the focus group wasn't reliable, then those results are misleading.
Absolutely. That's why when lawyers say, well, I did my own focus group. I went down, I was getting on the elevator and I did a focus group. And then, or I asked my wife, she's my best focus group. I'm like, there's no way that's even remotely reliable, because you're feeding the information in to get what you want out. So having good recruits is part of that. Obviously, presenting the other is part of that. But I think for lawyers who feel like this is my stumbling block, is recruiting the right people, go to an employment agency, right? There are plenty of employment agencies that will work with you. There are plenty of recruiters. That's all they do, is just recruit. And if you want to be super DIY, then sure, slap up a Craigslist ad, figure out a way to vet some people. But, most lawyers have 20 things on their plate. We talked about our things to do list ourselves. Like, it's really, really long. So if you can delegate to a professional and they get it done and you can get your focus group, then just do it that way, right? And like I said, you don't have to be a trial consultant. There are lots of recruiting companies that would be happy to fill your Zoom up with 8 people who fit the parameters that you want, right? And it's just kind of one of those things where don't put that as a barrier, because there's lots of ways to get help with recruiting that you don't end up with the pool of people who, it's a bunch of people just drive Uber all day, right? So people who actually go to work, have, all the things that you would want, or even representative of your actual jury pool.
Can we talk about that a little bit more? So the geography, right? Like I could be completely off base, but for whatever reason, and maybe I'll learn this lesson the hard way, I don't put too much stock into where people are from. And for example, like where I practice primarily, we're in Henrico County, which is a suburb of Richmond, Virginia. So that's a metropolitan city, right? Henrico, I mean, it's a suburb, right? So fairly similar to Richmond. But then we also have jurisdictions around us, for example, Hanover, arguably a lot more conservative. Chesterfield, maybe also conservative. And the talk, at least among the plaintiffs bar, is can't get good verdicts in Hanover, right? Or Chesterfield, good luck, right? I've seen so many just amazing trial lawyers like go to like Western Arkansas, Satch Oliver comes to mind, and kill it, right? So my thought is like, well, I mean, why can't you get a good verdict in a place like Hanover if there are people like Satch Oliver? Now, Satch Oliver, of course, is exceptional, but who's knocking it out of the park in Western Arkansas. Do you see a difference in geography, right? I mean, I can see the difference between, or I do believe there has to be a difference between the person who lives in or near a city and then maybe the person who is their biggest, the population of their town is 500 people, right? I guess I could probably, I appreciate that, but otherwise, I think I'm kind of hard-headed. So I'd be interested in your thoughts as to like what you see when it comes to geography.
I think that it's geography is part of it, but what I really look at is more of like what people in the area would be experiencing. So when I pick a group for, for focus group, and we're going to be running all different kinds of stuff. Every hour we run a different case. But it's all personal injury cases. Like I generally draw just a really large circle: Texas, Oklahoma, New Mexico, right? Like we can have a wide swath of people, but what I don't want, and especially if they're kind of Texas cases or in that area, like I'm not going to pick somebody from New York because their life experience is going to be very different. like again, this rural versus urban, but also like even just little things that people would key on and cause not necessarily disturbance, but it would be like, well, that's not what it's like here. Oh, well, and so then you kind of have this side conversation that you don't really want them to be spending time on. So I think that when you're recruiting, it's not as big of a deal as long as you're taking into consideration. I don't think it's as important. I know there are people out there who say it must be in this jurisdiction. If it must, then it must. But I think you can draw from people and get all kinds of great information out of focus groups. Now, the other thing you mentioned, which is people complaining about, oh, it's too conservative, or, oh, you can't get a good verdict there. I mean, I think that is all a mindset, because it is all about case framing and sequencing and understanding who your audience is. There are tons of amazing lawyers that go into some of the most conservative places in Texas and get $200 million on a wrongful death. I mean, it's all about mindset. I mean, you can use focus groups to figure that out, but you can also just understand like there is a way, and a lot of it has to do with case framing and sequencing and understanding what are the values, because all conservative people are going to have some set of values as well. It's not impossible to find out.
Case framing is incredibly important. Actually, we're preparing for trial in 2 or 3 days up in Winchester, Virginia. So hopefully the episode will not come out before that trial. So I'll share what I've been working on today, but I've been working on our opening statement, and taking a step back, what I've noticed, and it's intentional, is that 95% of it, if not more, is focused on liability and defendant's conduct, and also the defense's choices, right, in how they've defended this case. Now, this is a soft tissue, admitted liability, but there is property damage. So definitely an individual defendant. So definitely a difficult case from my perspective, because you've got the individual defendant, you've got the admission of liability. So they're presumed, I guess, in some respects, like to have a reasonable posture. So everything I'm trying to do now is to frame it to show, I think, that we're the reasonable party and they're the unreasonable party. And it's amazing to me, like, how many different ways you can tell a story. And from what I've kind of learned, and I'd love your thoughts on this, is that the way to tell the story is to focus on the conduct, on the defendant's conduct, much more so than damages. Is that right? And I guess if so, why? And if not, please slap me. But
No, I don't know who would, I don't know who would disagree with you at this point in time. I feel like that is the way, like if you listen to other trial lawyers podcasts, if you go and listen to, like, read a book like that, it is defendant's conduct comes first, right? We talk about the defendant first, when we are the plaintiff. And it is so important because, again, thinking through, what does primacy tell us, right? Which is the first thing you say is the most remembered thing. And as between two things, whoever gets to go first generally has just a little bit edge up on persuasion. So thinking what you're talking about first and how you're implanting that in their minds, it's so critical. And if you start out talking about somebody's injuries, it's just not going to strike people. And so that's where a lot of times people will come into a focus group and they'll test out an opening statement and they'll start right there. And I'm like, oh man, what happened? We just, there's so many things that go in with that first thing that you start with, that focus. But yeah, I think, I don't know many people who would disagree with you that you don't start there.
Sure. Why is it that starting with damages and starting with your client's injuries, even if they're horrific, for example, why doesn't that move the needle from your experience doing all these focus groups?
I think it's human nature to want context. And I understand that you can start with a hook. Let's just make a little clarity here, okay? There's a lot of opening statements that will start with a hook. They start with a stat. They start with a sentence, right? Something to grab attention, right? And then they move into the defendant's conduct, or maybe even a little bit of education piece. And I think when we focus in on the injury, people immediately think that we are trying to pull on their sympathy cords and try to make them feel bad and try to make them persuade them that way. And people are over it. That is just, people know when they're being sold, they don't like it. They immediately put up their hand, and we fall then into that lawyer greed trap. And that's, oh man, because they just think, oh, that's what this whole thing is, just about money, right? And so you really want to stay away from that. But then also, again, it's truly about, like, thinking through primacy and thinking through about case framing and what is it that truly can prevent what happened here? Well, it's conduct. Okay. The result is the result. It's the conduct here that we want to try and have someone be accountable.
Ben Gideon, right? Or I think you've had a podcast with him.
Yeah. Yeah. I was on his and he came on mine.
Awesome.
Yeah.
I saw him speak at Trial Lawyers University in Vegas, probably 3-ish years ago. And there was a line that I guess I still haven't forgotten. So it must have been a good one, and I listened to his podcast, of course, too. Him and Rahul do a really, really great job, but it was, verdicts are to deter conduct and damages are just the means to do so. And that stuck with me because I agree, right? Like, it's, the verdict is to say, stop this, right? Make the world safer. And damages is just the mechanism. The compensation is just the pressure to actually do so. Do you find that to be true in the cases that you work on?
Yeah, absolutely. And I think that's, like, let's take your case with your soft tissue injury. Those are some of the hardest cases because most people out there have probably done the exact same conduct driving their car. Maybe they didn't hurt anybody that time, but we've all done the, oh shoot, we sped, or oh shoot, we didn't put on our, and maybe something bad didn't happen, but that conduct is so familiar, to everybody when they drive a car. So those are some of the hardest cases, I think, to try, are soft tissue car wreck cases, because so many people sitting on the jury have the same point of view as the defense.
Sure. Yeah. It's just an accident, right? Like, which actually I lost emotion. I'm a crazy person. So in Virginia, our model jury instructions use the word accident a whole bunch. But to me, accident's kind of got a mental state element to it, right? Collision's a far more neutral word. And so I've been successful sometimes trying to get the court to modify the instructions to get rid of accident and use collision. In this case, the judge was like, listen, the model says accident, we're sticking with accident. But Cause you just hate when, like, at least from my perspective, you hate when it's like, guys, it's just an accident, right? And then you go to the whole, like, well, planes don't have accidents, they crash. Trains don't have accidents, they wreck. So why do cars do anything differently? So yeah, I agree 100% that they're incredibly difficult cases. And for us, we're not boarding any specials. Like we're not doing medicals or anything like that. So it's going to be a pure non-economic damages case. So who knows how that will turn out.
I'm sure it will be great, but they are some of the hardest ones. But the conduct is the focus, right? And so it's just, and I agree with Ben Gideon 100% that that's what we're there for, and that's what juries can do something about.
That's right. That gives them something to change, which is why when we do get punitives, it can really open up the possibilities for the client, because you can actually tell them then, right? Like you get to come back and send a message, whereas we can't just in a regular negligence case. But one thing that I've found, I'd love your thoughts on this, is especially for a case like this soft tissue case, admitted liability. In this case, the driver went through a red light at an intersection and did so because the sun was blinding him and just didn't see the light, right? And so didn't stop. And obviously we're going to focus on that and the dangers that are associated with that conduct, but that's it. Otherwise, I try and say this in voir dire, but it's not like the defendant meant to hurt our guy. He was just made a poor decision, right? So what I've tried to do, and we'll see if it works, it's worked in some cases before, is not just stop with the defendant's actual conduct for the specific event, but then also talk about the choices that they have made, not necessarily that person, but the defense team has made in how they've approached the litigation. So for example, it's one thing to say you're sorry. It's another thing to come back and actually fix it, right? Like the broken window analogy. And then look at what they did here. They went out and paid how much to get this doctor who never met with the client, who didn't treat him. But he's now reviewed the records and has this opinion that the treatment isn't related after some arbitrary cutoff 3 months after the fact. So we've tried to almost like weaponize the strategy that the defense uses to again show that they're the unreasonable party, we're the reasonable party. Have you seen that before? And if so, like, does it work? Does it not work? Or?
It does. And I think what you're really doing is there are people who will be sitting on the jury who have gone through a claim with their car before, and they know how a pain that it is and how long it takes, and that is not fast. But there are a lot of people, those people generally don't end up on the jury, of course, right? But then there are a lot of people who don't know the process, and they don't understand what happens when you have to go through this, because they automatically think, well, the plaintiff is the one that drug us all here. They just want a bunch of money. Like, they're unreasonable because they wouldn't settle yet, right? But you're flipping that on its head and saying like, whoa. Like, here is the process which led us to get here, right? Here's the context with which you're making this decision, right? And I think that's so helpful for people to know, because you're not coming at it, you could come at it a very like, here's all the evil things, right? But you're coming at it from, here's context. Let me just educate you on how the process works, and so I think it's very helpful and done, in a right way.
Yeah, something you mentioned that something I'm working on is trying to be more neutral, at least before we get to kind of closing and rebuttal, because I don't want to come out and say, look at this evil defendant, this evil defense, right? Like I need to work on allowing the jury to come up with that conclusion themselves, right? And for me, I get super passionate and I just want to, just go after it. But it's something that I'm working on, because I've heard from many people, and I'm sure yourself included, that if the jury comes to the conclusion themselves, right, it's far more powerful than if we just tell them, right?
Yeah, absolutely. I think that's anybody learning anything. I mean, there are definitely things that we need to be very direct and forward about when it comes to the jury, so they know where we stand. I think that they really look for guidance from lawyers from both sides, right? And so we don't want to miss that opportunity to give that guidance, but that's where you're giving guidance and not judgment, right? So that guiding teacher, here, look at all these things, right? And all this possible, what could it not be? But I do think that is a very thoughtful way of doing it and being neutral and being the teacher and just, empowering them to make that choice.
So, Elizabeth, we have a lot of young lawyers and law students who listen to this podcast, many of whom I hope want to be trial lawyers. Otherwise, why would they be listening to it, right? But
You never know.
can you share some advice that you think would be helpful to them as next steps, potentially, to learn how to get better at doing this stuff?
I think being a lifelong learner is probably the best place to always be curious, to be looking to go to the next CLE, to finding different seminars to go to, listening to different podcasts. I mean, one of the cool things about being a young lawyer now is there weren't podcasts when I was, you to go find a new seminar, it was like somebody would tell you about it, even though the internet existed. But there's so many more resources, and sometimes we just cram a lot of information in and we don't study it. And so that's where I would say, be a good student and take something in and really study it. If it hits you, I mean, trust me, there are tons of seminars I've gone to and I'm just nothing really stuck out to me. And other ones I go to, I have to come back. I love all of this stuff. I'm not grabbing all of it. Let me come back and get more. So I think being a lifelong learner, being curious with all the opportunities that we have to learn, just to keep going at it, even though you may not be sitting at a place where you have that opportunity to do trials right now. If you keep at it, you will, it will come there. But because I know that frustration sits there for many people who I want to be doing this right now, but the opportunity doesn't sit in front of me. If you keep pushing, I promise it will come.
Right. And that's where focus groups come into play, right? Get your opportunities.
Focus groups help, but yeah, I know. I mean, it's kind of one of those things where if that's really what you want to do, you will study and find the firm that feeds that versus maybe where you are now. But pushing yourself to be the best where you are at that time, and maybe it's now you have the opportunity to be learning and studying, and then you get to the next place where you actually get to apply it.
Well, Elizabeth, this has been a lot of fun. Thank you for joining us. And actually, on that note, we'll see you here in Texas, in a week, 2 weeks, I think, for the Linear Trial Academy. So yeah, constant learners, right?
Yes. Thank you so much for having me. I really enjoyed it.
Thank you.
Thank you for listening to this episode of RVA Trial Lawyers, Virginia's Trial Lawyer Podcast. For more episodes, check out rvatriallawyers.com.